So good evening, everyone, and welcome back to session 4 of our training series entitled Doing Business with DCF. Tonight, our topic is contracts, and we have special guests with us here tonight. A little while ago, I emailed everyone the actual slides for tonight so that you can have those, whether you want to look at them as you go or deal with them after. They're in your inbox, but nevertheless want to introduce our speaker for tonight. After we finish, when we get to the Q&A session at the end, I do have some updates for all of you as it relates to our DCF 101 session next week and how that will be used to answer a number of your questions that you've had so far. So with that being said, allow me to introduce attorney Kevin Joyner, who operates the law office of Kevin R. Joyner. He has over 17 years of experience in law, from trial law to dealing with criminal defense law, real estate law, work with small businesses. So he is very well versed in this concept of contracts and is here tonight to give you some basic knowledge as it pertains to understanding, reading contracts. So in your work as a small business, you hopefully will have some insight that helps you moving forward in the conduction of your business. So with no further ado, I'm going to turn the floor over to Mr. Kevin Joyner, Esquire. The floor is yours, Kevin.
All right. Thank you, Jimmy. Good evening, everybody. How's everybody doing?
Good evening.
Hello.
Hello. All right.
Hi.
Hi. And I think, Jimmy, meant there might be some other people that'll be patching in as we go, so that's fine. So this is contracts. I guess we can call this kind of like a crash course in contracts law. And so I've been in business as a small business owner as well for the last 17 years with my law office. So, you know, just like you all, I deal with a lot of this stuff. Even though I'm an attorney, I still deal with contracts and vendors and relationship and business relationships that require me to have some of these agreements written down. So I'm going to go through, and if there's any questions along the way, I'll take some questions and then we can save the rest for the end of the presentation. So let me just, this is not, oh, there we are. Okay, here we go. All right, so contract. When we talk about contract, so exactly what is a contract? So a contract is probably one of the most frequently used concepts when you talk about day-to-day, whether it's in your personal life, whether it's in your business life. You know, there are a lot of contracts and you may not even realize that you entered into a contract, but contracts are everywhere. We use them, again, on the personal side, and then as small business owners, large business owners, contracts are like something that exists every day. So what governs a contract? There's two ways in which contracts are governed. You talk about common law, and then you talk about statutory. So common law, the difference between common law and statutory is common law is something that's created based on precedents. So if there were a situation where one property owner sued another property owner because property owner number one has some large machinery in their backyard that creates some kind of pollutant and noise pollution for other neighbors. There isn't anything written in any law book that says that you can't have this piece of machinery there. However, neighbor number two decides to sue because it is impeding on his quiet peace and enjoyment. A judge then decides that, well, there isn't any statute that says that neighbor one can't have this machinery, but however, it is interfering with other neighbors, and therefore I'm going to rule that this piece of machinery is now prohibited. That's common law. It isn't written in any book anywhere. It's based on the decision that comes out of a court. Statutory law is where there is something written on the book, whether it is a state or a federal law that says that, I'm just going to call it cogwheels machinery. Cogwheel machinery is not allowed in any residential neighborhood. And the statute says that any residential neighborhood or anything within 10 miles of a residential neighborhood is prohibited for a cogs wheel. That's written in the statute books. That's statutory law. So that's the difference between common law and statutory law. There is some contract law that is derived from common law, but then there is some statutory law that governs, how contracts are handled, whether or not a contract is a viable contract. And sometimes the statute will determine who's in the right and who's in the wrong. So Article 2 of the Uniform Commercial Code, it governs contracts involving the sale of goods and adopted by much of the common law of contracts. So this is what is going to be most relevant to you as small business owners when we talk about the sale of goods, and kind of in that sale of goods is also included, the sale of services. So where Article 2 and common law differ, Article 2 prevails in the sale of goods. If a sale involves both goods and services, the court will determine which aspect is more dominant. So essentially meaning that when we talk about the sale of goods, so sale of goods, apples, oranges, I'm selling apples or oranges. There is a buyer, they purchase these apples or oranges. There is an issue with those apples or oranges. And Article 2 would determine, whether or not the seller of those goods was in the wrong, or if they were in the right, if there was a breach of contract that existed. So contract, what do you need to form a legally binding contract? There's a couple of different parts or elements that are necessary in order to have a contract. So definition, a contract. Basically, a contract is a promise or set of promises for which law gives a remedy. And so what that means is if I have an agreement with my neighbor that I'm going to provide a service, and in return of that service, he's going to provide me a certain amount of money. There is a protection for both of us in that if I do not meet my part of that agreement, my neighbor then has a remedy. And that remedy could be where I have to complete whatever services I agreed to provide, or let's say the services were provided, but they weren't provided to the satisfaction of my neighbor, or they were substandard if they were measured against, what the expectations are in that particular industry. And in that case, I may be required to reimburse my neighbor for whatever it is he paid for. So the performance of which the law in some way recognizes as a duty. So there are duties that go back and forth between the individuals on both sides of a contract. So the first part, or how a contract is formed, is there's an offer. So an initial communication of an offer creates the power of acceptance. So again, I provide apples and oranges. I go to my neighbor and say, hey, I've got these great apples and oranges. I'm selling them for $4 a bag. That is an offer. The offer is, I'm going to offer you these oranges. In exchange for that, I'm looking for money. So the response of an offeree, I go to my neighbor, I say, here are apples and oranges, $4 a bag. Acceptance of that offer in this situation would be my neighbor giving me $4, which in turn tells me that he's accepted my offer of $4 for a bag of apples and oranges. And in exchange, I'm giving him the apples and oranges. So consideration, Consideration is the value exchanged by the parties. So in this situation, this scenario, the consideration on my end are the bag of apples and oranges. The consideration on the end of my neighbor is the $4 that he's going to pay for this bag of apples and oranges. Mutual assent, agreement on the terms by the parties. So mutual assent, and I'm giving a very simplistic example here. Obviously, it can get a lot more complicated, but the mutual assent in this scenario that I've given, agreement on the terms by the party, is if my neighbor gives me the $4, that means that he is agreeing to pay $4, and in exchange for that $4, he is accepting this bag of apples and oranges. So the apples and oranges and the $4 are essentially the mutual assent in this contract formation. Then you talk about, again, whether or not a contract is valid. And so when we get to the legal aspect of determining, just whether or not this contract is valid, we talk about legal ability of the parties. So capacity, who has the capacity to enter into a contract? And we'll go into more detail in each of these sections as we go through the sides. Legality, legal subject matter and purpose. And then the necessity of form, that's the writing. Is there a writing required for certain contracts? So contract formation. There are two different types of contracts. There's a bilateral and a unilateral contract. So what a bilateral contract is each party exchanges a promise for a promise. So the example here is that seller promises to sell Blackacre to buyer for $10,000, and buyer promises to purchase Blackacre for that price. So there are bilateral or promises that are exchanged. Blackacre is going to be sold for $10,000. Buyer agrees to pay $10,000 for Blackacre. Acceptance with another promise in return. So I promise to sell you Blackacre, you promise to pay me $10,000. That's a bilateral contract. So there are promises that are going both ways, from buyer and seller, or service provider and customer. A unilateral contract, and how it differs from a bilateral contract, is it does not involve the exchange of promises. So only one party makes a promise, the other party is required to do an act in return for that. And as service providers, if any of you are small business service providers, you are probably dealing more with unilateral contracts. So Susan promises to pay Charles $5 if he will deliver a textbook to Rick. Charles is not obligated to deliver the book, but if he does in fact deliver the book, Susan is obligated to pay him $5. So in this case, as a service provider, let's just say the service that you're providing is cleaning homes. And so the agreement is that you as a service provider are agreeing that you are going to clean the home, and in exchange for that, you're going to receive $100. So you're providing a service, and so long as that service is provided, you're going to receive $100. So acceptance with the act. So the minute that you start and finish the cleaning of the home, that $100 is required to be paid. So contracts are frequently described as expressed, implied, or quasi. So an express contract is, two neighbors are having a conversation in the yard. One neighbor, again, he has these oranges and apples that he is growing in the backyard. He has a discussion with neighbor number 2 and says, hey, I've got some great apples and oranges and I'll sell them to you. Each party knows the terms and conditions of the contract. I'll sell those apples and oranges to you for $4 a bag. So the terms and conditions is that you're going to get apples and oranges, and in exchange for those apples and oranges, you're going to give me $4. So that's an express contract. An implied contract is formed by manifestation of assent or other than a written or an oral contract. So I go into the barbershop, I sit in the chair, the barber cuts my hair, a contract is formed. The assumption is that after that haircut, I'm going to pay the barber $20. So going back to my example of apples and oranges, I have a bag of apples and oranges. I bring them over to my neighbor's house. We have not had a discussion about them. I leave them on his steps. He comes out in the morning. He takes those apples and oranges. He brings them into his house. So at that point, his actions tell me that he's accepted those because he hasn't returned them to me. So then the expectation is that he's going to pay me the $4 for those apples and oranges. So a quasi contract, not really a contract, it's constructed by the courts to avoid unjust enrichment. So what do we mean by that? So let's just say that there is a scenario, again, neighbor one, neighbor two. Neighbor one is dropping apples and oranges off to the neighbor's house. And the neighbor has no idea where these apples or oranges are coming from, but they assume that they are a gift. So they bring them in the house, the family consumes them. Day two rolls around, neighbor one brings over another bag of oranges. They bring them into the house, they consume them. So after about 2 weeks, neighbor number one sends over a bill saying, hey, you owe me $20 for the last 5 bags of apples and oranges that I sent over to your house. Neighbor two says, I never agreed to pay you for the oranges. I had no idea that, I was being charged for them. In fact, I didn't even know that the oranges were being left on my steps by you. Neighbor number one says, okay, well, I'm going to sue you for them. So now the court has to decide, because there is no written contract, there was no oral contract. So it's left to the courts to decide, in fact, whether or not neighbor number two is required to pay neighbor number one. Now, in this situation, my guess would probably be that a court would rule that neighbor number one is out of the money. So we're talking about a nominal amount of money, and the fact that, there was no messaging left with the bag that said, hey, $4 a bag. So neighbor number two was never aware that there was a cost to this. And so in that case, that could be, again, common law that's established based on precedents, where it essentially says that, hey, if you leave a bag of oranges on your neighbor's step, but you don't leave any information, there's no writing, there's no price on it, then basically those things are going to be free to whatever neighbor takes them in and consumes them. So a quasi contract promotes fairness and prevents injustice. So in this case, it may seem that it's an injustice to neighbor number one who is providing these apples and oranges, but then it also sends a message to neighbor number one is that, hey, you can't just leave apples and oranges on the neighbor's step without some sort of communication, whether it's orally or written, to say, hey, this is the cost if you are intending to keep these apples or oranges. So first steps of an agreement. Is there an offer? So we have to figure out whether or not there's been an offer. An offer, a manifestation of an intention to be bound. So the offer, again, my apples and oranges example. I go over to my neighbor and I say, hey, I've got bags of oranges, $4. Terms must be definite. So I can't tell you that the apples and oranges are $4, and then when you go in the house, you come back out with your $4, and I say, oh, the price of the apples and oranges just went up to $6. So an offer must be definitive. So the offer is $4. Advertisement is not generally an offer. So IHOP advertises in a local paper, incredible offers, breakfast specials for $2.49. This is not an offer. It lacks specificity and definitiveness of the terms. So it doesn't tell me exactly what I get for $2.49. So when I walk into IHOP and I say, hey, I want an order of pancakes, I want an omelet, I want 3 pieces of bacon, I want a coffee and an orange juice. And then when they bring the bill, my bill is $17, and I turn around and I say, hey, no, but your advertisement says $2.49. That's what I'm gonna pay. In this case, if this was brought before a judge would decide that, well, this is not really an offer. There are no specifics. This advertisement does not give me any information on what exactly it is that I get for $2.49. Now, this is different from my example of the apples and oranges. I tell my neighbor, I have a bag of apples and oranges, I'll sell to you for $4. So my neighbor knows that he is getting 1 bag of oranges for a price of $4. Oh, I'm sorry. I lost my place here. Okay, we're back. So did offer terminate with acceptance? An offer lapses after a stated term or a reasonable time has passed. So if I give my neighbor this offer, $4 for a bag of oranges, my neighbor doesn't respond to me, I go back into my house. The next day I come out, my neighbor brings me $4. The question is whether or not, does that offer still exist? In this example, I would say that it doesn't. The offer probably expired at the time that it was given, by the simple fact that there was no action on the part of neighbor number 2 to either say, yes, I accept that offer and I'm going to pay $4 for those apples and oranges, or by his actions in that he goes into the house, grabs $4, brings it out, and turns it over to neighbor number 1. So offer made, 3-to-1 acceptance, 10-to-1 results, no offer, reasonable time has passed. So again, a certain amount of time must pass. So if I made an offer to my neighbor, say, hey, I've got apples and oranges this week for $4. Neighbor number 2 comes back 3 weeks from now, hey, I want 4 bags of oranges. I want to pay $4 for them. Here's $16. Does that offer still exist? In this scenario, no. Verbally, neighbor number 1 extended the offer. I have $4 bags of apples and oranges for this week. After that week has passed, simply that offer goes away. It does not exist anymore. So revocation of an offer. An offer terminates when the offerer revokes the offer. So apples and oranges, $4 for a bag of apples and oranges. All of a sudden, neighbor number 3 comes along and says, hey, Kevin, I'll give you $6 for that bag of apples and oranges. I turn to neighbor number 1 and I say, bag of apples and oranges are no longer for sale. I've now revoked the offer. Offer can be revoked anytime before acceptance. So let's just say that I made this offer to neighbor number 1, $4 for a bag of apples and oranges. Neighbor number 1 says that I accept that. I'm going to go into the house. I'm going to get $4. I'm going to bring it back and I'm going to pay for it. In the meantime, neighbor number 2 comes along and says, hey, Kevin, I'll give you $6 for that bag of apples and oranges. Neighbor number 2 comes back out with the money. And I say, they're not for sale anymore. I'm selling them to neighbor number 2 for $6. In this scenario, if we were looking at a situation where neighbor number 2 says, well, you just breached the contract that we had, decides to sue neighbor number 1. This sits in front of a judge. The judge is looking at this. So the facts are is that neighbor number 1 said to neighbor number 2, I'll sell it to you for $4. Neighbor number 2 says, I accept that offer. I'm going to go get the money and come back. In this situation, a judge would most likely rule that neighbor number 1, who's selling the apples and oranges, breached the oral contract because there was an offer and there was an acceptance of that offer. And even though neighbor number 2 had not paid the $4 just yet, the offer had been verbally accepted. So direct revocation, offeree told directly that the offer is revoked. So verbal communication, offer is revoked. Indirect revocation, offerer engages in conduct that indicates he changed his mind and the offeree is made aware of that conduct. So I say to my neighbor, I'm going to sell these apples and oranges to you for $4. Neighbor number 2 does not verbalize whether or not he is going to accept them, but instead turns and goes in the house to get the $4. In the meantime, neighbor number 3 comes along and hands neighbor number 1 hands him $6. Neighbor number 1, in exchange for the $6, hands over the apples and oranges. This is indirect revocation based on neighbor number 1's actions. The original offer is withdrawn. Rejection of an offer. So an offer is terminated when the offeree rejects it. Apples and oranges, $4. Neighbor number 2 says, I don't want to pay $4. He's rejected the offer. Neighbor number 2 counter offers and says, I'm not going to pay $4 for them, but I'm willing to pay $2. Again, it's a rejection of the original offer. And now neighbor number 2 is trying to create a new agreement at a new price. So death of a party before acceptance terminates a revocable offer, but not an irrevocable offer, like an option. Money paid to hold the offer open. So what we're talking about here is that, again, neighbor number 1, neighbor number 2, apples and oranges. Neighbor number 2 agrees to purchase the apples and oranges for $4. He's going into the house. He trips, bumps his head. He passes away. That offer essentially at that point passes away with neighbor number 2. However, neighbor number 2 says, hey, I've got $2. I need to go and get the other $2, but here are the $2 that I'm paying towards the $4 for the apples and oranges. Let me go and get the other $2. Again, on the way in the house, neighbor falls, bumps his head, he passes away. Now, because he's paid that initial $2, that offer is now held open. So neighbor number 1 now has an obligation to keep that offer open. Now, obviously, neighbor number 2 has now passed away, but his estate has the opportunity to either follow through on this offer or to say, hey, you know, we are, due to the circumstances, neighbor number 2 passed away. The rest of the family doesn't like apples and oranges. We'd like to have the $2 back. The offer is now terminated or revoked for that reason. Okay. So has the offer been accepted? The language of the offer controls acceptance. So email states, Stan, you can accept this offer only by reporting to work. Stan emails back, I accept the offer. Is this an offer? This is not an offer. The email specifies that the only way that you can accept this offer is by reporting to work. Apples and oranges. I tell my neighbor, the only way that you can accept this offer is by paying me the $4. So neighbor number 2 says, I accept the offer, $4 for the bag of apples and oranges. He leaves to go and get the money. In the meantime, here comes neighbor number 3. Neighbor number 3 pays $6. Neighbor number 1 sells those apples and oranges to neighbor number 3. Neighbor number 2 is upset. He sues. This is in front of a judge. A judge is going to look at this. The questions are going to be asked is, what was the offer? How was it made? Was it accepted? So in this case, the offer is, I'll give you this bag of oranges if you pay me $4. The actions of neighbor number 2 were, yes, he verbalized that he wanted to buy it, but he had not paid the money yet, so the offer had not been accepted. So starting performance. Starting performance is a bilateral contract in acceptance. So the offer, Jim offers me $5,000 to paint his house. I start painting the house. Offer does not specify how to accept. So Jim says, I offer $5,000 to paint the house. I start painting the house. There is no indication of when that $5,000 is to be paid. Is it to be paid at the end of the process, after the house is finished being painted? Is it being paid in installments? There's a $2,000 installment that's required, or 50% is upfront and the remaining 50% is paid at the end of the project. So starting performance in a unilateral contract is not acceptance. Completing performance is acceptance. So if you remember the difference between bilateral and unilateral. So a unilateral contract, again, which I'm assuming that a lot of you as service providers are probably entered into, are unilateral contracts. So what that means is that there is an agreement. I am going to provide therapy. Each therapy session is going to be $50. And so the start of that therapy is the beginning of that contract. But after each therapy session, now $50 is due. So completing performance is acceptance. So I am agreeing to pay you $50. And in exchange for that, you are providing me with services, therapy services. So at the end of my 1 hour therapy, I'm paying you $50 for that service. Mailbox rule. Acceptance is effective when it is mailed. Protects the offeree from against revocation once he's mailed an acceptance. So what that means is that if I sign a contract and I drop it in the mail, so I'm agreeing to therapy services, I sign that contract, I send it back, I've now essentially accepted those services. That contract now becomes binding. So example, May 7th, actor gets a letter offering him a role in a new film for $7,000. On May 8th, he mails it back. On May 9th, he gets a letter revoking. Result, offer accepted, contract is enforceable. So if for some reason this movie production manager finds a better actor at a cheaper rate, and he decides that the offer that he mailed you, he does not want to honor that. And so he sends you a letter saying that he revokes it, but you've already mailed back your acceptance. You've already signed the agreement saying that you were going to accept this role for $7,000. There's one or two things that is going to happen. Either they have to honor that, or ultimately what happens is that a judge will determine, well, what are the damages? And let's say that you turn down an offer for another part with a different company. because you accepted this one. And in the interim, this particular producer is now trying to revoke. So a judge is going to look at that and is going to determine, well, there are damages here, but for you accepting this position, you could have had this other position, which would have paid you a little bit less money, $4,500 instead of $7,000. A judge could rule that producer number one, who sent you the initial offer, still has to pay you, even though you haven't done the work at that point. But he had put an offer out there, you accepted it, he breached the contract. You're entitled to $4,500, which is the loss of income that you would have gotten had you had the opportunity to accept offer number two. So is a contract legally enforceable? There are certain things that have to be in place for a contract to be legally enforceable. So lack of capacity. Minors are not allowed to enter into contracts, at least not on their own, not without a parent or a guardian who signs off on it. An intoxicated individual. If someone is intoxicated at the time that they enter into a contract, I go to my neighbor. My neighbor is clearly intoxicated. He's got a beer in his hand and he's got 12 empty beer cans sitting on his picnic table in his backyard. I go over to him and I say, hey, I'm willing to sell you these apples and oranges, but I'm going to sell it to you for $500 a bag. He's so intoxicated that he agrees. Sure, $500, that's a great price. He sobers up and realizes what he did. If he can prove that he was under the influence at the time that he entered into the contract, chances are a court is going to rule that the contract is not enforceable. Mentally incompetent, same thing. Someone who doesn't have the mental capacity to understand what it is that they are reading or writing makes a contract unenforceable. Excuse me. There are some exceptions. Incapacitated parties are liable for necessaries: food, clothing, shelter, or medical care. Economic duress, rarely a defense unless the seller is the only source and the buyer needs right away I'm sorry, hold on, let me just going to slide over so I can see this whole screen. So the buyer needs right away what is being offered. So there's contracts to buy $1,000 worth of blankets for $50. Seller changes the terms to $75.99. Buyer agrees because seller is only source and he needs them right away. So a perfect example of this is I own a restaurant, and due to the shortage of drivers, the fact that there aren't enough people on the docks to accept cargo that's coming in, there are shortages and a lot of food items. And so where I would originally or had an agreement with my provider to buy a case of chicken wings for $90, I now pay close to $200 because there is a shortage. So even though my agreement was for $90, the simple fact that, due to the shortage of tractor trailer drivers, obviously the impact of the pandemic, the cost of travel, the cost to get these things from one place to another, the price has gone up. So even though my contract says $100, I'm now paying more than that because there is just simply a shortage and I can't get it anywhere else. So a misunderstanding is where there were maybe the terms were not clear. And the buyer agreed to accept the terms sound like a really, really great deal, but he misunderstood that the quantity that he was getting wasn't 100 per box, but it was 10 per box. So a mutual mistake about material facts. Now, A agrees to sell a bike to B, neither aware that the bike was destroyed in a fire. So again, this is a real life example. I go into Home Depot last week. I'm talking with the gentleman in the tool rental department, and we are discussing a trencher. He's showing me how to operate the trencher, how to put the gasoline in it, how to start it, how to turn it off. At the end of that, I say to him, I want to rent the machine. Unbeknownst to both of us, there was another Home Depot representative who was at the register with another gentleman who came in, says, I want to rent a trencher. As far as this Home Depot rep knew, the trencher was available. He rents the trencher. I come up to the register, and although we had a verbal agreement that I was going to rent this trencher, when we get to the register, we find out that the trencher is no longer available. I'm sorry, I need to adjust my screen so I can, okay. So when, excuse me, one moment. So we talked about contracts, and contracts being either written or sometimes contracts can be oral. The more complicated or detailed things are in the promises, the mutual promises, or the amount of money that's being exchanged for the services, it's important to have a contract in writing. The best way to operate is to have a contract in writing, because this way both parties understand exactly what the expectations are. Usually what happens when you're negotiating a contract, it's easier when it's in writing, because if there are terms that are missing, if there are terms that you don't like about that contract, those things can be tweaked until both parties are satisfied and feel comfortable. So I would say written contract is probably what you want to do 99% of the time. So most oral contracts, they are enforceable. However, certain kinds of contracts need to be enforced. They need to be in writing. A statute that requires certain types of contracts to be in writing, the transfer of interest in real property. So if you're selling a piece of property, whether it's a plot of land or a plot of land with a building on it, that has to be in writing. If the performance cannot be completed within a year, if full performance was theoretically possible, no writing would be required. So if it can't be completed within a year, so I am looking to purchase a home, I have a plot of land, I want the builder to come in and build that home, but that home has about 30 bedrooms, 16 bathrooms, and there's a pool that's going to go in, there's a tennis court that's going to go in, and we're living in New England. It's probably not possible that all that can get done within a year's time. That contract needs to be done in writing. The sale of goods, anything that's $500 or more. So if I'm selling apples or oranges and I'm selling, let's say I'm selling pallets of apples and oranges and the price is $501, has to be in writing. Suretyship, a promise to answer for the debt of another, that has to be in writing. So a co-signer, I'm signing for a car, my dad is my co-signer, he can't verbalize that, yes, if Kevin defaults, I'm going to pay what he owes. That contract has to be in writing. He has to sign something that says that he's agreeing to pay in the event that I default. Contract modifications have to be in writing. So the initial terms of the contract were that I am going to provide apples and oranges to my neighbor on a weekly basis for $4 a bag. There is a shortage that all of a sudden happens. I can't get the product like I used to, so it's costing me more to get the product. I then go to my neighbor and say, hey, you know, the cost to provide these apples and oranges to you have gone up. We need to come to a different agreement where you're going to pay more for the apples and oranges. That has to be in writing. So it must be in writing only if contract as modified is within the statute of frauds. So not the original contract. So if it's outside of the original contract, it has to, well, it doesn't apply. So we're only talking about the contract and what was in the original contract. The original contract was valid. And so therefore any modifications to that would be valid. The rule of contract laws that govern many different types of contracts, including, and these are probably some of the contracts that you guys see come across your desk that you enter into as service providers. There is an employment contract. There are construction contracts, installment contracts, contracts for the sale of land, contracts for the sale of goods, manufacturing contracts, lease agreements. Oh. Let me see. I hit something here. Hold on. Okay, we're back. Oh, you know what? That's our last slide. So just to wrap everything up and to summarize it, contracts are very important. Like I mentioned at the very beginning of this presentation, you know, we enter into contracts on a daily basis, not even realizing that we've entered into a contract. A lot of those contracts are verbal contracts. Some of them are solely based on our actions. So another example of a contract is when you walk into a grocery store, when you walk into Walmart, you have a shopping cart, you are putting items in that shopping cart. The expectation is that when you get to the register, you are going to pay a sum of money in exchange for those items. It's an oral contract and it's all based on your actions. And as service providers, you know, it's important that you get everything in writing. So this way you understand from your perspective what your expectations are going to be as a service provider. You know, whether it is, you know, the hours of that service, what's going to be involved in that service. Is there going to be any follow-up? So if I am a therapist and I'm providing therapy to individuals, and one of those individuals comes in, they have an hour session with me, they reach out to me over the weekend, and I have a 30-minute phone conversation. Well, is that in the contract? Is there anything in the contract that says that, you know, therapy is going to be from 6 o'clock to 5 p.m. every Wednesday, and in exchange for that, there's $50. So if I pick up the phone and have a 30-minute conversation with one of my clients, and I give them 30 minutes of therapeutic consultation, am I able to charge for that? And so now it becomes a question, well, what's in the contract? What does the contract say? Are there any provisions that make room for that? And so these are some of the things that you want to think about when creating contracts. Sometimes there are things that come up with contracts that aren't in the initial contract, but you may not realize it until somewhere down the road. Like this example, you have as a counselor, and you are providing counseling, but then you tell your patients, hey, if you ever feel like you need to talk, here's my number, here's my email, reach out to me. Wasn't discussed initially as a service provider, but it's come up with one of your clients. They feel like they'd like to have access to you even outside of their agreed upon hours. Is that something that can be gone back and modified? It certainly can, but it would have to be in writing, and obviously it would have to be negotiated between, service provider and the offeree. I guess I'll take some questions if anybody has questions, comments. I'm just going to stop sharing my screen now.
Sure. Does anyone have any questions for Attorney Joyner? No questions. All right, we'll give one more opportunity. Any questions for Attorney Joyner?
Now, I don't know if that's good or bad. That could mean like, I don't know what in the world he was just talking about. Or, I don't know.
I have a clarifying question. This is Evelyn. Just when you were speaking about if I receive a contract, I sign it, I mail it in, but the other person can revoke, do they have to receive it? Oh, I'm trying to clarify now. The example that you gave earlier, I mail in I sign it, I mail in the contract. Does the person need to receive it in hand, in a boat or anything like that? Or it's just the matter of me signing and returning it that binds that person to the agreement, the contract?
So you signing and returning it. So I've had contracts with the state of Connecticut, and I'll use that as an example. They emailed to me a contract that says that we are going to pay you, I don't know, $300 an hour for legal services that you provide to this particular client. They email it to me, I DocuSign it, and I send it back. The minute that I hit the send button, the state of Connecticut is now obligated to that contract. Now, there's this caveat to it, is let's say that this particular client that they have never has any legal issues that come up. So are they obligated to pay me that $300 an hour at that point? No. But if, client comes in, has a consultation, I invoice the state of Connecticut for that $300, they're obligated to pay that. So yes, the minute that you either drop that contract back in the mail after you've signed it, or the minute that you've signed and you've hit the send button to send that email back, it is now a contract between yourself and whomever.
Okay, thank you.
Mm-hmm.
I have a question. Can you hear me?
Yeah.
Weird.
Okay. So if you have a contract to provide a really specific service,
Mm-hmm.
and they ask you to do something else, do you do an amendment, or would you create a whole nother contract for the second service?
You could amend you could amend the contract that it really depends on, how detailed this other services that you're providing. But you can amend the contract to include, so let's just say that your contract provided that you were going to provide sleep therapy, and 3 other types of therapeutic services. And the other party comes back and says, well, hey, I want you to provide these other 3 services along, or could you do these other 3 things along with what you're doing? If it's easy enough to amend the contract to include, so including in the service that we already provide, we are also going to offer these 3 additional things and make them specific. It doesn't necessarily require you to do a whole new contract.
Okay.
You could just amend or add to the contract that you already have. But then the other thing you have to think about is, adding these additional things is there additional cost to it? So if your original agreement, let's say to provide sleep therapy, it's $50, but to provide this other type of therapy, it's $150. So the cost is different. Then you might want to look at having a different contract if it gets too complicated and adding to the contract that you already have.
Thank you.
I have a question. There was a contract that we needed to amend, and what we ended up having to do was to have that contract. There was amendments, a couple of amendments throughout, and then it had to be initialed in those areas and then re-signed.
Mm-hmm.
And to my knowledge, that's sufficient. Is that correct?
So are you talking now when you say amended, were they amended or were they changed? So I know like sometimes in a contract, there might be, again, let's say that one of the services that's listed in there, the parties agree that, well, we don't need this service, so you don't need to provide this service, so you cross it out and you initial it.
No, it was definitely like a couple of add-on points. It didn't change the current scope of services. It was just adding on a couple of additional things or a couple of additional requirements. Do you understand what I mean now?
Yeah. But it was so, yeah, I mean, I guess as long as it's in a writing and both parties have signed it, whether it's physically handwritten into the contract that you've already that's already in place, or that you've drafted a separate document that's entitled amendment to the contract dated November 2nd, 2021 with these new terms. As long as it's in writing and it specifies exactly what those changes are, or whether they're changes or additions. And then you just want to, if it is a separate writing, and I know sometimes, it's easier just to kind of write it in at the bottom of what's already contracted because it's there. If it is a separate writing, the important thing is that you want to reference back to, contract dated November 1st, 2021. The following items amend that contract or are added to that contract to be included.
I have a question.
Yeah.
In relation to the example you gave earlier about the actor who agreed to, believe it says like $7,000 to take a particular role.
Mm-hmm.
And they found an example of someone else who could do, I'm sorry, I'm in transit while I'm on this meeting, I apologize. Found someone else to do the role. And the example you gave, was that the person was only obligated, now again, I don't know if it was only, but just an example you gave, was obligated to pay if there were damages because a person maybe perhaps missed another opportunity. But suppose that person didn't have another job opportunity, that this was just all they had, this offer for $7,000. Would that offer still, the one who made the initial offer, would they be obligated to fulfill it in under those circumstances, or just if there was some other form of damages?
No, they could still be obligated to pay. So, I accept this offer. I don't have any other offers, but I accept this offer for $7,000. So I'm now, I know that I just signed this contract. I'm getting this $7,000. So I know that, my bills for the next 4 months are set. I'm good. And so I'm anticipating that money coming in because I've signed this. If I go to a judge and I say, look, he offered me $7,000 in anticipation of that, I plan to pay my light bill, my water bill, my rent, and I even made a promise to pay off part of my student loan. A judge would probably look at that and say that, the offerer has an obligation now. You entered into a contract. That contract was accepted based upon the terms of acceptance, which was I mailed you a contract. Hey, Kevin, $7,000 to accept this role. You just need to sign this and send it back to me. And I do that, and you don't fulfill your side of it, then it's a breach of the contract. And a judge could look at that and award damages. It could be $7,000. It could be more, depending on, at that point, what I brought in to show that my damages, accumulated to or surpassed that 7,000.
Thank you.
Yeah.
Any other questions for Kevin? All right, going once, going twice.
I'll close out with this. Contracts are sometimes they seem tedious and unnecessary. And I can say, even as an attorney, there were times when I was thinking like, you know what? I don't really need a contract. I've known this guy, or I know this business. We've been doing business for the last 5 or 6 years. So we don't need to put this in writing. You have to assume that anything is possible and anything that can happen will happen. You agree to buy a box of sweatshirts that you intend to sell in your store after you put your store logo on them, and it's your buddy who orders those sweatshirts for you. You don't have a contract with him. He orders them, he sends them over to you. He's got an invoice that he's now looking to get paid. But guess what? The sweatshirts that you received are not the ones that you expected. And so now he's like, hey, Kevin, this is just strictly business. I need my money. And you're like, but I can't sell these in my store. And so now there's a dispute over it. And so my point is that it doesn't really matter who it is. You always want to make sure that you are entering into a written contract, because again, that is what's going to be the vehicle that drives the outcome if there is a dispute. And you may enter into 100 contracts and never have a problem, but it is that one contract that you enter into that could create a whole host of problems. And obviously, usually with contracts, it has to do with service or with money on the other end. So it's important to make sure that even the smallest things, you want to have them in writing, even if it's something, a contract is as simple as writing something on a piece of paper that says, hey, I agree to pay X for what I'm paying. I expect to get 3 red boxes, 6 blue boxes, and 1 orange box.
All right. So if there are no other questions, I'll thank Attorney Joyner. Counselor, we appreciate you for being here with us tonight. Thank you Before we wrap up, I want to share something about next week, just to give you some understanding of our last training, which will be DCF 101. And that specific training is going to be held kind of in two different ways. So the first part of it will be DCF actually sharing some information with you that they feel you need from them. The second part will really be a moderated panel, if you will. So there'll be an opportunity for you to interact and ask all the questions that you have of DCF as it pertains to literally anything that you need to know, want to know. And so my request to you, because we want to make sure that whatever questions that you have, we have the right people on the training to actually answer them. So my request to you is, today is Tuesday. We ask that over the next 48 hours, that you think of your questions, forward them to me via email, and we will compile those questions and share with them so that they can make sure that as many people as necessary who need to be on the phone, on the Zoom call to address your questions are there. So over the next 48 hours, if you compile your list of questions, things that you need to know, want to know, have to understand, need specific feedback on from DCF, please put those in writing and forward those questions or topics to me, and I will share with them. When I receive them from you on Thursday, they will have them no later than Friday. I'll probably wait till Friday morning just in case questions come in late. But nevertheless, I will meet with them on Friday of this week with those questions, and they will be, people will be on the call next week to answer any and all questions you have pertaining to DCF. So with that being said, are there any questions for me? And if there are not, in your inbox, once again, you should have the slides from tonight's presentation. Also, the link to the webpage where all of the trainings are captured. So everything that is recorded is already up on a page. You can watch or rewatch any of the trainings that you'd like and have access to that anytime that you want just by clicking on that link. So if you have any questions before we meet again, please reach out to me. And let me know how I can help. If you'd like to schedule time with Attorney Joyner, let me know that as well. We will arrange hours where based on his availability, and we'll get you one-on-one with him to deal with any issues or challenges or anything you'd like to do and need legal perspective or legal help to accomplish. So with that being said, I hope that you all have a great evening, and we'll see you next week. Good night, everyone.
Thank you. Have a good night.
All right. Good night.
Good night.